due to filing of earlier petitions, petition numbers 29909, 324.98 and 32643 of 2023 and subsequent proceedings in RP number 535 and 536 of 24 and writ appeal numbers 787 of 806, 835 2024 also cannot be sustained. In the petition number 4414724, the last in the series of petitions, the court has expressly left all conventions of the petition is open. Given the above, none of the judgments cited by the respondents applied to the facts of the case. There was nothing for a court not to say nothing is open in my case because the entire cause of action was not there. The doctrine of res judicata to apply, I must say with all humility, the doctrine of res judicata is not understood to many of the lawyers and judges. The doctrine of res judicata to apply, there must be a complete termination of list. If your lordship dismiss this case, I kept my writ petition ready to be filed, which will come before the single bench for a new cause of action. Unless there is a finality, unless there is a termination of cause of action, there is no res judicata. Dismissing a case is of no consequence. I tell you, Manisha Mata, she is the president of the MSME Association. Because she filed 76 times. Ever so many times dismiss. But nothing. There is no res judicata. Supreme Court dismissing a case is of no consequence. Because for a doctrine res judicata to apply, the cause of action is a disputed evidence. And that must, when it undergoes a process called transitive judicata, the cause of action, which is a disputed evidence, merged with the decree of a court, and thereafter it ceases to be in existence, and that is called doctrine of merger. If the cause of action is not found to be in existence by the court, then the doctrine of merger is not abstracted. It is only res judicata. And therefore, and what merges what is decided. If a decision was on the public law remedy, then that alone comes to res judicata. Other issue, that is called issue estoppel. It doesn't go to res judicata. It's only issue estoppel. Other rights persist. Other cause of action persist. If my properties are still not taken possession of, someone was taken possession of, the properties are to be sold. There is a long line of litigation pending. There is no res judicata. Res judicata pro veritate accipitum. That comes when order 1 rule 1 CPC. Therefore, my lord, the petition, my lord, they codified the law, the common law principle for the first time in 1859 for the colony called India. And there, my lord, the common law principles were, my lord, codified. That is why you find all the principles, the doctrine of estoppel. Res judicata you find in the CPC section 10, stay of suit. If one suit is filed, another suit of the same matter between the same parties is filed, then the latter suit has to be stayed. When there is a decision, that is called res judicata. But there is a constructive decision, there is a constructive res judicata. If there is a proceedings of a representative nature, then there also the concept of res judicata applies. Section 12, bar of suit. Then order 1, rule 1 CPC. All parties, all causes, all controversies to be brought before one forum. So order 2, rule 2 CPC, all claims to be sold. And a litigant cannot be allowed to permit this without the permission of the court. If he does, then there is a bar. So then order 39, section 39, specifically fact, section 41 specifically fact. Therefore, all the code, the CPC is a codification of common law principle. And the doctrine of concept of res judicata is the very foundation on which the concept of administration of justice is built. Therefore, any system which could work would bring a scenario where all cause of actions, all parties are brought before one forum. It is impossible for a borrower to be lost. Impossible. Because the concept of creation of a tribunal in substitution of the civil court is unworkable. Anybody who has got elementary knowledge of basic jurisprudence will never think of creating a tribunal in substitution of the civil court. If our lawyers and judges should stop thinking of creating tribunals, all tribunals should be abolished. And we should build the with the lower court, civil court. Article 226 should be abolished. What is Article 226 has reopened? What has been abolished in England? In England there are two streams of justice, the Chancery Court and the Common Law Court. And that led to difficulty. And read Bandam, he fought for it, for amalgamation. And after his amalgamation, only the Judicata Act of 72 and 73 and 1873 and 75 came into existence. During Banda's time, 1852 Act came. 1852 Act says, Common Law Court can grant equitable remedies, equitable court of equity can grant common law remedies, and this great great lakuna, what they did on the appropriate way, that deficiency was resolved forever. Even before that was done in UK, in India, when CPC was amended, all parties, all causes, all controversies, and the court of civil under the civil court under the CPC is a court of plenary jurisdiction, empowered and competent to adjudicate any issue of a civil nature under the sun. It was a true constitutional court. And that is why under Order 27 rule A of the CPC, when a constitution issue is there, notice has to be issued to Attorney General. So therefore, there is no point in talking about res judicata. There is no res judicata. Res has never come to an end. The dispute between me and my friend is continuing. It will never continue it. It will never continue it. Therefore, this was all argued extensively. The judgment does not at all discuss anything other than res judicata. And res judicata can apply only if there is a factual education. And here, in my case, the court found there is a res judicata. In the same